Hello and welcome to today's video. Today's video is on the topic of British free speech law. Throughout this video I hope to explain the limits of free speech in Britain, what protections you have to your free speech, and anything else related. It's often said by sensible centrists that you don't have free speech in the UK. And to some aspect that's true. I mean, free speech is not an absolute right, especially in English law. It's a right that can be limited by law, which causes some debate. And I know there'll be people in the comments who say, what's the point in having free speech if the government can limit it? And I may be sympathetic towards those arguments, but I don't think it's necessarily fair or honest to say that in the UK we don't have freedom of speech. The freedom of speech law in the UK has some protections, and I hope that this video will explain it to you. We'll start with limits to freedom of speech. There are civil limits to free speech. So you cannot say something about someone that is untrue. The law of defamation is the main and most obvious civil limit to freedom of speech. When discussing defamation in the UK, you have slander and libel. Slander is basically spreading rumours about people verbally that aren't true. So an example of this would be if I said that my work colleague to another person was a nonce or a paedophile or had done this, and that rumour got spread around, anyone spreading that rumour, provided it was untrue, would be committing slander. In my opinion, I think the law of defamation in the UK is quite good. And I like how it's a civil law, not a criminal law. I think there should be civil limits to freedom of speech because I don't particularly think that a media organisation or anybody else should be able to start rumours about you that could ruin your life. So if you are a medical student and say someone you don't like says that you had a camera in the girls' toilets, you're probably never going to work clinically again. So I don't think it's an unreasonable limit to freedom of speech to have civil limits where someone who does make those kinds of comments and starts rumours can be held accountable for it. Moving on to libel. Libel is the posting or the making of a statement in a permanent form publicly that is untrue. In libel law in the UK, a statement has to be seen by only one person. It doesn't have to be a large statement. With libel law and also with slander, the law of slander, the onus is on the person who made the statement to prove that what they've said is true. So it's a very interesting process for those of you who maybe don't have a defamation law system that is similar. But defamation law essentially ensures that someone, normally large institutions like media companies, cannot make a statement about someone or an organisation that is not true. The problem with defamation law in the UK is access to justice. Suing someone for defamation is very expensive. So it's only the super rich or people who have legal insurance as a result of their professional body. Some doctors will have insurance that covers defamation, who will be able to sue someone for slander or libel. Or libel, not liable. Because, as I've previously said, it's very expensive to sue someone for libel. So libel law in the UK gets criticised for that reason. But in terms of principles, I think it's perfectly understandable that the law should protect someone or an institution from having statements made about it by media organisations or by people that aren't true. The most serious types of libel are for people who are claimed to be terrorists or paedophiles when it's not true. So normally, if a newspaper is saying that someone's a terrorist or a paedophile, they will have to prove to a very high degree that that's true. I'm going to go on to now common law limits to free speech. This is your contempt of court and the criminalisation of discussing publicly an investigation, normally by the police publicly. Contempt of court limits to freedom of speech are often said by judges to be essential for a democratic society. To some extent, I agree with this. For example, I wouldn't necessarily agree that someone shouldn't be able to report on a trial while it's going on in a way the jury can see and may affect the jury. However, what I will say is normally in countries where they don't have strong contempt of court laws like they do in the UK, the jury are normally sent to a hotel or something like that. So there are lots of different views on the common law limits to freedom of speech, but the reason common law limits to freedom of speech, like contempt of court, exist is it would interfere with a trial. So just to explain it briefly, in the UK you cannot discuss a police investigation while it's ongoing publicly unless something is already in the public domain, and then you can only discuss what is in the public domain. Also, trial dependent, you can't report what's going on during a trial. Obviously there are exceptions to this, but that's the general rule. Criminal limits to freedom of speech. The main criminal limits to freedom of speech are under the Communications Act 2003 section 127, and this limit to freedom of speech is based on politeness. However, there are many people, and I would have sympathy with those people, who argue that the limits to freedom of speech here are unreasonable and tyrannical, because all you need to do, in theory, to be guilty of a crime is post something that's offensive. And that has caused problems like the trial of Count Dankula and Mark Meekan. There are people like that who get prosecuted under this section all the time. But what I want to draw attention to is that British free speech law is primarily focused, especially at the criminal end, is focused at stopping comments that are grossly offensive and statements that are grossly offensive. You might be asking, what is something that is grossly offensive and who decides that? The judges do. So what I would say is, if you're using Twitter to talk about politics, phrase it, anything you post, in a very polite way, and avoid using buzzwords and slur words such as tranny, those type of things. Words that might be objectionable or reasonably objectionable. There is statutory guidance on the Communications Act and stuff like that, and normally people who have been prosecuted under it have normally been prosecuted for something that would seem grossly offensive. So you have people who get prosecuted under the Communications Act for posting words that include racial slurs, or comments that include racial slurs, or anything like that. I believe there was a teenage girl who's prosecuted under the Communications Act for posting rap lyrics on Twitter or Instagram, and because those rap lyrics had racial slurs in them, that person was prosecuted. So whether or not I agree with the criminal limits to freedom of speech, I think what can be learned from it is, I think this is probably a cultural thing to the British. Expressing opinions in ways that are vulgar, crass, truculent is probably not a good idea. However, there is an issue with that, because to get attention on social media and to build up a big following, normally you have to be quite controversial, or at least interesting. And using very academic language when you discuss politics doesn't normally attract much attention. I mean, I use lots of academic language and phrase my tweets in a very polite way, and I don't get very much attention. People like Carl Benjamin and people like that, who are probably more crass on Twitter, have larger followings because of it. So I do understand the argument that people should have the right to offend people, but in the UK you don't. Offending someone can be a criminal offence. So if you're discussing politics, it's probably not a good idea to use certain language, because it may be a criminal offence. And also, using certain language, even if it isn't criminal, may seem to distasteful to people who would otherwise support you. What protections do you have for freedom of speech? In the UK, you have protections to your freedom of speech. However, as I've previously said in the criminal slide, or earlier in the video, the protections for your freedom of speech are within the limits of politeness, normally. I mean, I think most people I'm aware of who are Holocaust deniers who have gone to prison, I don't like the term Holocaust denier because I think it's unfair to a lot of people, because some people who you would call Holocaust deniers don't necessarily say the Holocaust didn't exist, didn't happen. Some do, some don't. Most Holocaust deniers who have gone to prison have normally gone to prison because they've used certain racial slurs regarding Jewish people, or posted songs that would be particularly offensive. I'll leave the link to a music teacher or someone who is apparently a Holocaust denier who posted, I can't remember what it was an anti-Semitic song, and that was, if I remember rightly, a violation of the Communications Act. So in terms of protection, I would say the general protection you have for freedom of speech is within the realms of politeness, providing it is a sincerely held political opinion and it's discussed in a polite manner, or a manner that isn't too objectionable. I would say you're normally fine. So you have protections for your freedom of speech under the Human Rights Act, or freedom of expression, Article 10. So what this does is, this legislated protection stops people like employers from firing you because of your sincerely held belief in your freedom of speech, as long as it's within reasonable limits. In the case of Forstater and CGD European 2021, section 286, I'll leave that in the description so you can look it up. I'll leave the citation, that is, so you can look it up. The judge said, or the judges of the employment tribunal said, that because Mrs. Foster's comments about the transgender community were not phrased in a way that is extremely objectionable, even though they were, I believe the judge said, in poor taste, don't quote me on that, that it would be unfair for an employer to discriminate on Mrs. Foster based on her political views and her expression thereof. So, to conclude, what you need to know is your freedom of speech in the UK has very strict limits, and the strict limits are on politeness. Because of the ideology of the current ruling class, you can get away with saying more offensive things the more regime approved your opinion is. But as a general rule, I would say that your freedom of speech and your discussion of political topics should be kept as polite as possible. If you keep your political speech as polite as possible, it's very unlikely that you will suffer any legal consequences. In fact, if your political speech and you're on the sensible centre, or you're a sensible centrist, is kept as polite as possible, it's very unlikely for you to be prosecuted or even be fired from work for holding a position. The only exception to the protection and social protection is that employment bodies or professional bodies have different rules to employers. So there hasn't been a case where someone has been fired or disbarred or struck off for holding a particular opinion. Though there's a turf barrister who got complained about by people in the transgender community, trans activists, who tried to get her struck off the bar, or disbarred as we lawyers would say, and basically the bar ignored it. That's a positive sign that as long as what you're expressing is reasonable or is presented in a reasonable way, you're very unlikely to suffer legal and professional consequences. For sensible centrists, especially, any political discussion needs to be true. So any comments made about people publicly need to be true. Lawrence Fox got sued for calling someone who works for Stonewall a paedophile, and that's obviously libel because you can't prove the person's a paedophile, so you're going to get sued. I would generally say sensible centrists should not call people pedos or imply they are pedos unless it's true. Otherwise you're going to get sued and it's in poor taste and makes you look bad. Once you've been sued for libel for saying something that isn't true about someone else, the only person who looks stupid is you. So make sure everything you're saying about other people is true. Secondly, don't talk about active police investigations publicly, because that's a good way to get into trouble, or trials that are ongoing, because that's very likely to get you into trouble. Thirdly, and has been discussed, avoid using buzzwords or slurs, because there's just no point. It will get you into a lot of legal trouble, and it's distasteful. Even if you're not discussing things online, using racial slurs can in some cases qualify as a hate crime. So don't under any circumstances, especially if you're a sensible centrist, use any kind of slurs or any kind of crass language if you can avoid it. Obviously you can avoid not using slurs. Don't use slurs under any circumstances, but you probably will be okay using crass language if it is appropriate to. My dad used to say there's a time and a place for everything. I believe when my dad used to say that, he was lecturing me about being drunk when I was a kid. I wasn't drunk as a kid, but I saw my dad come in drunk when I think I was about 10, and my dad said, "William, there is a time and a place to be drunk." And I think that's very good wisdom for freedom of speech as well, and making political statements. There is a time and a place for it. Thank you very much for watching. Please check out my links. My public speaking channel links are in the description, but I'm also going to link some of the articles and necessary legislation that I've discussed.